Me. So good morning everyone, welcome to panel 1. So I vividly remember attending a conference at Wuhan University when the tribunal's jurisdiction decision was announced. So China's loss judge Gao Zhiguo was there, right? The organizers paused the conference, and then Chinese legal and IR scholars immediately began debating on the implications of the decision. So what struck me after 10 years, right, was not really the legal arguments. It was the fact that everybody in the room on that day, realized that the arbitration proceedings, the award itself, had major diplomatic and strategic implications for the region. So then we had the final award in July 2016. So again, fast forward 10 years, legal positions remain unchanged, but the strategic environment has changed drastically, right? But today this panel will not focus so much on the legality of things. We have two panelists, and our discussant will be sharing his video online. He's unable to come. So today's focus will be on regional legacy, ASEAN responses, ASEAN centrality, maritime governance, economic security included. So with that, let me welcome my panelists on stage. So from Philippines, we have Deputy Assistant Secretary from the Maritime and Oceans Affairs Office, Secretary Rogelio Villanueva. Then from Malaysia, we have Associate Professor Muhammad Hamzi from the Universiti Sains, Universiti Sains Islam Malaysia. His research focuses on international maritime law. So, gentlemen. Yeah. So a bit of housekeeping rules. We have roughly about 10 minutes per panelist, and then we'll move on to about 10 minutes from the discussant who is unable to come. So he actually sent his recorded video, and then I will move on to open the floor to the audience for a Q&A. So I'll hand the mic over to Secretary.
Thank you, Irene, for that kind introduction. Mr. Julio Amador of Fax Asia, Professor Afrianza of Universitas Indonesia, His Excellency Ambassador Christopher Montero, Philippine Ambassador to Indonesia, esteemed Justice Antonio Carpio from the Philippines, all participants, delegates, panel experts, good morning. I will now read my presentation for this panel. This year marks the 10th anniversary of the South China Sea Arbitral Award, rendered pursuant to Annex 7 of the Convention. At the time it was issued on 12 July 2016, many viewed the decision through the prism of geopolitics. Headlines spoke of winners and losers. Commentators focused on the immediate strategic consequences. Several critics argue that its meaning will only be achieved when compliance is immediate and complete. For the Philippines, the award's significance was never simply about the Philippines and China. It was about whether international law can serve as a compass when the waters of international relations become uncertain. It was about whether disputes between nations can be resolved through reason rather than coercion, through agreed rules rather than unilateral assertion. The award is a resounding affirmation of the 1982 United Nations Convention on the Law of the Sea, or UNCLOS, and its dispute settlement mechanisms. It stands as a reminder that disputes must be resolved through peaceful means and in accordance with international law. Final and binding, from the moment it was issued, it remains an important contribution of the Philippines to international rule of law. The award clarified key legal questions concerning maritime entitlements, the nature of certain maritime features, and the rights and obligations of states under the Convention. For the Philippines, the award is final and binding under international law. Its significance extends beyond the immediate parties, and it contributes to the broader development of international maritime jurisprudence and reinforces the rules-based international order. The Convention's dispute settlement mechanisms remain central to the peaceful settlement of disputes and maintenance of international peace and security. Respect for international law, including decisions rendered by courts and tribunals established under the Convention, strengthens legal certainty, stability, predictability, and peaceful relations among states. It is essential to preserving the integrity, credibility, and universality of the Convention and the rules-based international order it embodies. A decade hence, the jurisprudence of the award has guided discussions among governments, scholars, jurists, and international institutions. It has strengthened a shared understanding of the law of the sea. Beyond its pivotal role in the peaceful settlement of maritime claims, the award reinforces the role of UNCLOS as the legal framework for sustainable ocean governance, upholding it as the constitution of the seas. The award clarified important obligations under the Convention relating to marine environmental protection, including duties concerning fragile coral reef ecosystems, biodiversity conservation, the prevention of severe environmental harm, responsible resource management, as well as the Convention's regime on maritime safety, freedom of navigation, and traceability of sea lines of communication. The Tribunal's findings on the protection and preservation of the marine environment, in particular, continue to resonate strongly within the evolving corpus of international law governing the oceans. The award was cited by the International Tribunal for the Law of the Sea, ITLOS, in its landmark advisory opinion on case number 31 on climate change and international law, issued in 2024. The ITLOS advisory opinion cemented the ocean climate change biodiversity nexus and affirmed how states' responsibilities go beyond the UNFCCC framework and also emerge from our obligations under UNCLOS, which undoubtedly means that the protection, conservation, and sustainable use of the ocean and its resources require the full breadth of international law. More recently, the 2016 Arbitral Award was again cited by the Tribunal in the MT Heroic Idun case, further cementing the award as part of the corpus of international law. The outcome of this proceeding contributed meaningfully to progressive legal certainty, clarification, and application of the Convention, particularly on issues relating to freedom of navigation, flag state jurisdiction, maritime enforcement, and provisional measures. The 2016 South China Sea Arbitral Award can truly stand as a guidepost for states on important maritime matters, such as the invalidity of excessive or historical claims, the proper assessment of status of maritime features, the activities at sea deemed prejudicial to the rights of the relevant coastal state, and the obligations of state parties for the protection and conservation of the marine environment. Ladies and gentlemen, the Philippines strongly champions compliance with decisions and rulings duly rendered through compulsory dispute settlement mechanisms under UNCLOS, such as the 2016 Arbitral Award, as well as respect for the advisory opinions that provide authoritative clarity to UNCLOS provisions, such as the 2024 ITLOS Advisory Opinion on Climate Change and International Law. The Philippines emphasizes that respect for the award is not a matter of political preference. It is an expression of respect for the international legal system to which states have voluntarily committed themselves. Upholding international law strengthens the predictability and credibility of the maritime order, upon which all states depend, particularly smaller and developing states. At the same time, the Philippines recognize the diversity of views among ASEAN member states regarding maritime issues, including the award. ASEAN's strength has always rested on dialogue, consultation, and consensus. Our objective should be to foster unity by building cooperation around principles that we have collectively embraced. Those principles are clear. All ASEAN member states are parties to UNCLOS. All ASEAN member states have committed to the peaceful settlement of disputes, and all ASEAN member states support a rules-based maritime order under international law. These shared commitments provide the foundation for ASEAN to address maritime challenges collectively and with confidence. The Philippines therefore believes that the 2016 Arbitral Award should not be viewed as an obstacle to ASEAN unity, but as a guidepost that complements ASEAN's commitment to international law. Respect for legal principles does not divide ASEAN. Rather, it strengthens ASEAN centrality by demonstrating that regional stability can be achieved through rules, cooperation, and peaceful means. In this regard, the Philippines welcomes the initiatives contained in the recent ASEAN Leaders' Declaration on Maritime Cooperation and supports efforts to translate ASEAN commitments into practical mechanisms. The establishment of the ASEAN Coast Guard Forum represents an important opportunity to enhance cooperation among maritime law enforcement agencies. Greater communication, coordinated responses to maritime incidents, joint training, and exchanges of best practices can reduce risk at sea, prevent misunderstandings, and build confidence among member states. On the other hand, the proposed ASEAN Maritime Center can serve as a valuable platform for strengthening regional capacity through research, information sharing, policy coordination, and institutional development. A stronger ASEAN maritime architecture will enable the region to respond more effectively to common challenges. Under the Philippines' chairship of the ASEAN this year, our theme, Navigating Our Future Together, reflects a simple truth. No nation can navigate today's risk alone, and our journey towards a peaceful, stable, and prosperous region rests on full respect, consistent application, and faithful compliance to international law by all parties. Our President, His Excellency Ferdinand R. Marcos Jr., aptly stated our unwavering conviction. The South China Sea must never be an arena of conflict. It must remain a sea of peace, cooperation, and connectivity, a body of water that sustains livelihoods, fosters trade, protects marine biodiversity, and unites rather than divides our nations. Thank you.
Thank you very much, Secretary Rogelio. So now we move on to Professor Hazmi. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi. Good morning, everyone. Let me introduce myself. My name is Mohd Hazmi. I got that a lot. People call me Hamzi, sometimes Hazim, sometimes Hazima. In Australia, they call me Hazima. I do not know how that happened. Anyway, first and foremost, I would like to thank the organizing community, especially not only my friend, someone I regard as my mentor and my brother, Prof. Ari Arfiansyah, for having me over from the Philippines, Mr. Julio Amador, and also Irene for moderating this session, and my co-speaker, Secretary Rogelio. So good to be here. Jakarta is like my hometown. I travel to Indonesia almost every month. We have a lot of partners here, and it's very good to be here. And yes, I would like to share my presentation today more on the Malaysian perspective. Okay, so this is just a simple slide to introduce myself, and then where I work. This is where I work, my university that I'm based in. It's called Universiti Sains Islam Malaysia. It's I think it's the newest public university to be established in Malaysia, the closest to the international airport. So Ari, if you have plans to come to my university, I will invite you personally, because the airport is just 20 minutes away. And can we go to the next slide, please? Okay, right. The key message that I would like to share with you today with regards to the introductory part of my presentation is the award did not resolve the dispute, but it transformed the legal landscape in the South China Sea. That is something that we cannot deny. And from the Malaysian perspective, we have to admit that the award itself, it clarified the interpretation of UNCLOS. Because UNCLOS is something that Malaysia, it's like what has been mentioned by the previous speaker, ASEAN members are state parties to UNCLOS. That includes Malaysia, and it reinforced a rules-based maritime order, according to what has been clarified in the UNCLOS. I think everyone is clear on this. It demonstrated peaceful dispute settlement under international law. And Malaysia as a country, we have tried to make sure that any disputes, we would try to resolve it through peaceful means, and it continues to shape legal and policy discussion in the South China Sea. And hence, this is what we are having today, 10 years after. Right, and then can we move on to the next slide, please? And this is something that is really apparent. We are not a we are not a party to the arbitration, but continues to advocate respect for international law. So if you ask me whether or not Malaysia is in support to the arbitration award, the honest answer is that we just took note of it. We took note of it, and we have never expressed that's a simple answer. We took note of it because there are some parts, the parts that follows the spirit of UNCLOS. Obviously, we are in support of it, but in summary, we took note of what was being awarded in the arbitration. And as an ASEAN member, as a country that is located in ASEAN, where it is a zone of peace, freedom, and neutrality, Malaysia consistently support UNCLOS as the comprehensive legal framework governing the oceans. Like every country have their own constitution, so we look at UNCLOS as the constitution of the sea. Every dispute has to go back to UNCLOS, and we do not recognize maritime claims that are inconsistent with UNCLOS. And we believe in safeguarding our sovereignty and sovereign rights through international law. and support peaceful dispute settlement and diplomatic engagement. That's the reason why when we have disputes with Indonesia, we on Sipadan Ligitan, we managed to bring the case back. At that time, I was still doing my undergraduate studies. I was only 19 at that time in 2002. All right, the case was brought to the ICJ. And it was decided, Alhamdulillah, in favor. Okay, I'm in Indonesia right now. Okay, it was. It's decided that Sipadan Ligitan to be awarded to Malaysia, and also with Singapore. Irene, we had this Batu Putih case, whereby you managed to get the rock. Yeah, congratulations. But at the end of the day, the ICJ decided that Pedra Branca was to be awarded to Singapore, Middle Rocks with Malaysia, and we still have that South Ledge that we have to decide on. So this basically shows that Malaysia has always been in support of any dispute settlement that promotes peace. Even though the netizens may say something else, but we really support peaceful settlement. And obviously, the final point on this is on this slide is protection of Malaysia's maritime interests. More importantly, our position, Malaysia, Singapore, and Indonesia, we are the caretaker of Straits of Malacca and Singapore. That's the reason why we have to always go back to UNCLOS and international law. Okay, so just to give you a rough idea, can you move on to the next slide, please? Okay, this is the South China Sea. I just want to show where we are claiming, just a rough idea. Okay, Malaysia's claim based on its maritime entitlement goes on, okay, that red part over there. Can you click one more? Can you click? Okay, that part. So this is not drawn up to scale, but it's just to give you a rough idea what we are claiming in the South China Sea, or our sovereign rights claim in the South China Sea. If you look at the area that we are claiming, it is actually bigger than Sarawak and Sabah combined. I think so. That's how I look at it. So I'm not saying that this claim denies the claims of other states, but this is what we are claiming in the South China Sea as far as continental shelf and high seas are concerned. Okay, so, not high seas, I apologize, EEZ are concerned. Okay, can we move on to the next slide, please? Okay, and one more thing. We are, particularly Malaysia and Indonesia, we are caretaker states of Straits of Malacca and Singapore. We cannot run away from it. And those who are putting their claims on South China Sea cannot deny the fact that the Straits of Malacca and Singapore are two of the most important straits in the world. You close this down, and then all your, in Indonesia you call it BBM, in Malaysia we call it harga minyak, and the rest of the world call it oil. So it goes up and people will go crazy, right? So basically, these straits manage to, it's important for the for supply chain and economic well-being of all countries all over the world. All right, so basically, in order to preserve freedom of navigation in the straits, can you please click? Okay, all right. We have something that is called transit passage in the Straits of Malacca and Singapore that ensures that all passage of foreign vessels just for the purpose of navigation could not be impaired, hampered, or impeded by the littoral states. Okay, so why I'm saying this, because at the moment we have this ongoing issue in the Hormuz Strait, whereby there have been plans to blockade the Hormuz Strait, putting tolls and whatnot. We, as a country that follows international law, not on the issues on South China Sea particularly, we also want international law to be respected, particularly as a caretaker of one of the most important straits in the world, in order to ensure that the whole world will enjoy, will not be negatively impacted by what's going on. Okay, so can we go to the next slide, the final slide? Okay, so looking ahead, Malaysia will continue. Based on what I've said, we are not just to reiterate, we are not we are not the 2016 award centric. We are not centric of any other countries. We are UNCLOS centric. Malaysia is UNCLOS-centric. We have been members. UNCLOS has been enforced in Malaysia since 1996. We respect UNCLOS, and we will always uphold UNCLOS as the legal framework governing the oceans, to safeguard Malaysia's legitimate maritime rights and interests through international law. Like I said earlier on, we support peaceful dispute settlement. But something to note in the South China Sea, even though there are dramas here and there, we managed to coexist without going to, without resorting to military intervention. So this is something that we should realize, that even though despite all the differences, we managed to maintain peace and stability in this region, unlike other parts of the world, regions in other parts of the world. So we should always continue to promote an effective and substantive ASEAN-China Code of Conduct. This is something that we are still working on, and we should preserve regional peace, stability, and freedom of navigation, like what have been mentioned by the first speaker. So in conclusion, I would like to reiterate that international law alone cannot solve the dispute, but no durable solution can exist without international law. So with this, I would like to return the session back to Irene, and if there are any questions, I'll be happy to address them. Thank you very much.
Thank you, Hazmi. So sorry about your name just now. Okay, so apologies for myself and Secretary ducking down to back to the floor because we couldn't see the screen earlier. Okay, so now moving on to the recorded message. I think I would like to invite the two gentlemen to actually go back down. If not, we can't see the video. Yeah, so please, sorry, allow us to get off the stage first. Thanks.
Good morning. First, thank you to the organizer for inviting me. I had hoped to be with you in Jakarta today, but unfortunately the typhoon made that impossible. It is nevertheless a pleasure to join you even only virtually. My topic today is simple. 10 years of South China Sea arbitration, what has it actually achieved? Notice that I'm not asking whether the tribunal has legally right or legally wrong. That debate has been going for a decade. Instead, I want to ask a different question. Has a award made the South China Sea more peaceful? Because that, ultimately, is how we should judge any mechanism for dispute settlement. If a legal ruling cannot reduce tension, cannot build trust, cannot create conditions for political compromise, then we should at least ask whether it has achieved the purpose for which international law exists. My answer is straightforward. The arbitration changes the dispute, but it did not solve it. In many important respects, it makes the dispute harder to manage. Let me explain why. First, the award narrowed political space. Before 2016, China and the Philippines certainly disagreed over sovereignty and maritime rights. But disagreement did not prevent diplomacy. Two governments still talked. They still cooperated. They still reach for temporary arrangement when leaving fundamental disagreement unresolved. This is actually how many international disputes are managed. Not every dispute is solved. Many are simply prevented from becoming crises. The arbitration changes that. By presenting highly contested issue in definitely legal terms, it became politically harder for either government to compromise. Legal certainty produces political rigidity. Law did not replace politicals, it frozen politicals, and we can see the consequences today. incidents at the sea are no longer simply operational event. Within minutes, they became headline news. They become video on social media. They become test of national resolve. Every encounter is politicized. Every incident becomes internationalized. That makes crisis management much harder. Second, the arbitration makes ASEAN's job more difficult. ASEAN has never managed regional security by declaring winners or losers. Its strength has always been dialogue, patient, incremental progress. That's why Declaration of Conduct of Parties, DOC, was possible. That's why negotiation of Code of Conduct continues today. The process is slow, sometimes frustrating slow. But ASEAN has always believed that sustainable arrangement came from political consensus, not from legal imposition. The arbitration altered that dynamic. If one side insists the ruling is the only legitimate basis for negotiations, compromise immediately becomes much more difficult. Diplomacy becomes to disappear. Legal positions become political red line. Meanwhile, the South China Sea has become increasingly entangled in US-China strategic competition. External powers now play a much larger role than they did 10 years ago. That raises an uncomfortable question. Who is shaping the future of South China Sea? The country who actually lived here, or the country located thousands of kilometers away? For ASEAN, I believe that is a real strategic issue. Third, the arbitration also raises a broad question about the future of international law itself. Let me be clear. This is not an argument against international law. It is an argument about how international law preserves its own legitimacy. International law is strongest when states regard it as both legally sound and politically legitimate. That legitimacy rests on three foundations: restrained interpretation, procedure, fairness, and consistent state practice. The South China Sea arbitration remains controversial precisely because many governments and international lawyers believe this foundation were placed under strain. Take the procedure first. UNCLOS does not simply encourage arbitration, they require parties to exchange views before compulsory procedure was initiated. Yet, before commencing arbitration, Philippines never had substantial exchange with China on certain issues, on the central issue in dispute, like historical rights, the legal status of maritime feature, and maritime boundary delimitation, whether one agree with China's position or not. This procedural question cannot simply be brushed aside. Second, there is a question of jurisdiction. The tribunal maintained that it has not decided the question of territorial sovereignty. Yet, to reach many of its conclusions, it separated question of maritime entitlement from sovereignty and maritime delimitation issue that, in practice, are often closely intertwined. Many distinguished international lawyers, including scholars outside China, have questioned whether that amounted to an expansive interpretation of tribunal jurisdiction. Again, reasonable people may disagree. Many disagreement itself tells us something important. The legal issues were never as straightforward as they are sometimes presented. Third, perhaps most importantly, it is the principle of state consent. Every international court or tribunal ultimately derived its authority from the consent of the state, UNCLOS certainly established compulsory dispute settlement. But it also presents important exceptions, including the right of a state to exclude dispute concerning maritime boundary limitation, historical title, except through declaration under Article 298. That balance was carefully negotiated. It reflects a simple reality. States are willing to accept compulsory procedures only because they knew certain highly sensitive disputes could remain outside compulsory jurisdiction. If that balance is perceived to be out through judicial interpretation, confidence in system inevitably suffers. And confidence is not a secondary issue. It is a foundation upon which every international legal system rests. That brings to my final point. International law is not strengthened simply because a tribunal speaks. It is strengthened when states consist, accept, apply, internalize legal law in practice. 10 years later, that has not happened. The award remains politically and legally contested. Even government that public support the award has rarely relied on its more expensive legal reason when dealing with its own maritime claim. Taking Japan's Okitorishima as example, or we can look the Kingman's Reef of the United States. That is significant because customary international law developed through consistent state practice accompanied by opinion juris, not through repeated political statement, and so certainly not through diplomatic message alone. International law is not built by repetition, it is built by acceptance, and acceptance cannot be declared. It has to be earned. The issue is no longer whether one agrees or disagrees with every paragraph of the award. The real question is whether international law should become a mechanism for managing dispute, or another source for geopolitical contestation. I believe the answer should be obvious. International law should create political space. It should not close it. It should build confidence. It should not deepen distrust. It should help country negotiation difficult compromise, not convince them that compromise is no longer necessary. So, where does this leave ASEAN? I believe ASEAN should avoid two mistakes. The first is to dismiss international law. That would be wrong. Rules matters, law matters, peaceful disputes settlement matters. Second mistake is to expect too much from law. No tribunal can resolve dispute rooted in sovereign history, national identity, and strategic competition. Courts cannot replace diplomacy. Awards cannot replace political judgment. International law works better when it creates space for for political solutions, not when it closes that space. Let me finish with one final thought. South China Sea arbitration at 10. It should be an opportunity to ask more practical questions. Where is South China Sea today? Is it calmer? Is it safer? Is there more trust, more cooperation, more room for diplomacy? I think that answer was obvious. The region is more contested, more militarized, more internationalized. That should be concern all of us. The real challenge of ASEAN is therefore not whether to defend one league award, it is whether ASEAN can preserve its own centrality, its own diplomatic space, and its own capacity to manage regional affairs. Because ultimately, the future of South China Sea should be shaped not by league absolutism and not by geopolitical rivalry, but by regional dialogue, political wisdom, practical compromise. Thank you very much.
Thank you very much to the recording. So I invite my two panelists to come back up on stage. Theme for today, it's trying to coexist peacefully and to agree to disagree, right? And just as Prof. Zheng in his recording mentioned, the award is and the arbitration is not the be all and end all. We still have to fall back on cooperation, dialogue, which is what we come to today. So I'm going to abuse my right, as the moderator, a bit disruptive. I think one burning question is, does the award still matter? We are now 11 ASEAN member states. We only heard from 2. Unfortunately, we only heard from 2 today. So we have, 9 more to go, and we haven't heard, everything else. So does the award still matter? Given that we have all this kind of energy crisis and stuff like that. Thank you.
Thank you, Irene. Well, definitely the award matters. It's final and binding. It's the authoritative ruling that has clarified UNCLOS, especially the important provisions about the invalidity and lawfulness of expansive historical claims and the status of maritime features and the activities, especially the activities on the South China Sea that are prejudicial to the interests, especially of coastal states, when we talk about preserving the marine environment and in terms of promoting effective maritime governance. So for the Philippines, definitely the award really matters, not only for our country, but also for the international community, the user states, the coastal states, and everyone that has an interest in the freedom of navigation and overflight. For example, the sustainable use of marine resources even beyond areas of national jurisdictions. These are very important principles that are already part of the ruling. So for us, definitely this is one of the cornerstones of the foreign policy, maritime policy of the Philippines, along with UNCLOS. So Arbitral Award and the foreign policy and commitment to UNCLOS are the 2 core principles of Philippine foreign policy.
Hello. In order to respond to that question, I believe my friend here has already mentioned most of the things that I would like to to share. But I would like to reiterate what Mr. Secretary has mentioned just now, that even though Malaysia is not a party to the arbitration, and I did mention that our government's position is that we took note of the award without endorsing or whatsoever. We took note of the award, but personally, as a reader in law, reader in international law, I believe that most parts of the award is the interpretation of UNCLOS and international law itself. So if let's say, like what you said earlier, Irene, if it doesn't matter, why are we still talking about it today? It has been 10 years. if your child was born in 2016, it's already 10 years now going to school, right? So it means that it does matter in a way that it shows that this is how law UNCLOS is interpreted, okay? How, and at least in a way that the award managed to, if it doesn't resolve dispute, it is some kind of a, it is some kind of a, it provides justification for nations now to speak on issues pertaining to law of the sea, particularly on issues on the South China Sea. So even though it does not solve disputes, but at least it gives some sort of a leeway to move forward. So as far as Malaysia's position is concerned, I would again like to reiterate, we took note of it, and we believe that most parts of the awards, maybe a majority of it is being decided, being looked upon by interpreting UNCLOS. So again, if it doesn't matter, why are we still talking about it today? Yeah.
Irene, if I may also add, I think the important message of the Arbitral Award is that it proved that it debunked the view that might is right, because international law is the great equalizer, and the decisions, international law is not based on the size of a country's national territory or the size of its economic or military power. So that's a very important message that I think the other countries would find inspiration in the ruling of the Arbitral Award. Now, as far as maintaining peace and stability in the region is very important. The message here is that commitment to peaceful settlement of disputes. But as we have realized, the situation on the ground is not actually perfect. We have incidents, but we all have this chance to think, where does the stress, where does the pressure, where does the coercion come from? So that's a very important thing to think about, maintaining regional peace and stability. But where does the coercion, the provocation, and intimidation come from? So thank you.
Okay, with that, I'm going to open the floor to questions. So I'll take 3 questions first. Oh, great, we have 3 hands. I'll start with the gentleman. Oh, now, so I'll take the first 3 questions first. Sorry, but I'll come to you in a while. Yes, please.
Thank you. Thank you for the very insightful presentation by the 2 speakers. I have one question, actually, with the recent publication of the joint statement delivered by the US with some other states, which include some Baltic states out of the region. How actually your perspective from your own country, especially from Malaysia and the Philippines, regarding the mediation of the process in the South China Sea, because it shows that there are more interest from countries out of the regions. US is part of the strategic dialogue partners. They're already, every year, they're engaging with ASEAN. Japan.
Sorry, I'd like to, can you please, because we have quite a number of questions,
okay.
Can you make your point quick?
I just want to explore this perspective from your, representing your country, Malaysia and the Philippines. You see the phenomena of the inclusion of more states in joining the statement of the US in responding to the South China Sea Arbitral Award recently, which was published online. Thank you.
Next question from Andy.
Thank you. Rustian Suprianto, University of Indonesia. My question goes to Hazmi, my friend. I was wondering, because UNCLOS 1982 still applies to Malaysia, but Malaysia in its diplomatic statements also endorsed the new map of 1979, Peta Baru. So I would like to, your opinion, your views on the relationship between the 1979 map, which predates UNCLOS, and UNCLOS. Thank you.
One last question from the, yes, please.
Yeah, thank you. I see this forum is very fundamental to seek for the emergence of concrete and sharp resolution concept. Taking Malaysia, for instance, despite the country is not the participant of the Arbitral Award, but Malaysia should not forget as a claimant of South China Sea. So to me, as a participant of this seminar, would like actually to see any the emergence of any concrete and sharp resolution concept that we could discuss together. And also, I also criticize the position of ASEAN. I've been involving in the discussion.
I'm sorry to cut you off, but your main question would be what are the mechanisms?
So my question
mechanisms,
is
right?
actually,
okay, can we give the participants, the panelists, a chance to express their views on the questions first? Thank you. So we start off with the questions that was, the first question with Secretary.
Okay, thank you, Irene. The first question as regards the joint statement, I am not able to provide in detail the context of the joint statement because our office is not part of the drafting of that joint statement. But in general, the joint statement issued recently on the 10th anniversary of the Arbitral Award reflects the growing and increasing commitment and support of the international community to the Arbitral Award, particularly the concern about the threat and use of force, peaceful settlement of disputes, freedom of navigation and overflight, and the concern on promoting regional stability, not only in the South China Sea, but in the wider Indo-Pacific region. Thank you.
In response, I also like to agree with what Mr. Secretary has said just now. It shows that, like what Irene asked earlier on, it has been 10 years. So is it still important, the fact that that statement was made? It's actually shows that this arbitral award remains important. This arbitral award remains important in moving forward in order to ensure that UNCLOS is being respected and also all countries would ensure that what they do should follow the spirit of UNCLOS. So I believe I share the same view with the first speaker on the question raised by the first by the gentleman over there. And with regards to the second question about the 1979 map, I do honestly speaking, we are not planning to issue any other maps. I know Indonesia has issued a map in 2017, right? Okay, so the reason why we are not issuing a new map because we are still adamant with the claims back then. Okay, but there should be some adjustment because in the 1979 map, Pedra Branca is still within Malaysia's claim, but since things have changed back in 2008, so bottom line is that we are still following the 1979 map, and we have a number of overlapping maritime claims with Indonesia, particularly the ones in the Straits of Malacca, whereby our EEZ is still overlapping. So that's why we keep accusing each other of stealing fish, but we are not stealing fish. We do not know to whom the maritime zone belongs to. So in order to answer your question, the reason why we are not revising, because we believe that that map itself doesn't go against the spirit of UNCLOS. So I do not have any information whether Malaysia is coming out with a new map, but right now we are actually holding on to the 1979 map for our reference. Okay, so for the third question, sir, you did mention on Malaysia, we are not state party to the Arbitral Award, but I did mention that we even though we are not state party to it, but as one of the states that have claims on South China Sea, we have maritime claims on the South China Sea. We would like to see things to be resolved according to what UNCLOS has promoted, And that's the reason why at the moment we are trying to negotiate, we are trying to have more dialogues with claimant states and also with China or any other countries that are interested in issues pertaining to the South China Sea. Bottom line is that Malaysia will not resolve this issue with conflict that may destroy the region, because we believe in promoting peace in any dispute resolution that we are dealing with. So I hope that answers your question, sir. Thank you so much.
So again, we are back to the recurring theme of, we want to maintain peace in this region. So, through more dialogue, trying not to accuse people of stealing fish. But I'd like to come back to the point that fish don't stay in one spot. No matter how many maps you issue and however many lines you draw, fish swim freely. And, okay, so I'm moving on. I had two questions. Park, you were first. And I have a question from behind. So 2 questions for now. Can we have the mic?
Thank you. My name is Surya Viranto. I'm from the Indo-Pacific Strategic Intelligence. It is interesting for me to listen how the speaker gave the briefing about the South China Sea Arbitral Award. Yeah. My question is, in the 2016 South China Sea Arbitral Award is legally binding and binding under Article 296 of UNCLOS. Yet in practice has failed to alter the behavior of states that rely on power politics and effective control. Does it indicate a crisis in the effectiveness of the international law of the sea regime, what we call it UNCLOS itself, or does it instead demonstrate the need to reconstruct the rules-based international order by integrating normally legal authority or normative power, defense capability or hard power, and advanced maritime technology, smart maritime power? My question is, how can claimant state as well as Indonesia develop a conceptual framework capable of bridging the gap between the pure legal legitimacy and de facto implementation in the government of maritime security across the Indo-Pacific? Thank you.
Thank you, Park. We have one question from behind.
Okay, thank you. I come from China. Maybe most of us here have a common belief, that is to keep peace in South China Sea. So I have 2 questions to Philippine Villanueva. The first is, 10 years after the arbitration, has the award made the South China Sea more peaceful? From Manila's perspective, what concrete indicators shows that the award has reduced incidents, built trust, or created more room for compromise? And the second question is, if international law should create political space rather than close it, what practical arrangement is the Philippines prepared to pursue with China, even if the 2 sides continue to disagree fundamental over the award? Thank you.
Okay, thank you for your questions. It's quite directed at individual countries. Can I please draw out the questions and focus a bit more on ASEAN? So, panelists, when you respond, not just only from your own country's perspective, but what does it mean for ASEAN, at large? Yes, please. Thanks.
Okay. May I respond? I think the first question is addressed to my my Malaysian colleague. So for the question from our Chinese participant, as I said a while ago, this situation on the ground is not very ideal, despite the ruling issued on the 2016 Arbitral Award. But we would like to share the 4 core dynamics of the Philippine maritime statecraft. Of course, our dynamic respect and to uphold international law, especially UNCLOS, that's very basic. Second is we have a proactive policy of maintaining our bilateral and multilateral mechanisms. What I'm saying is that despite the situation of at sea, at the ground, we maintain communication, diplomacy, and dialogue with China as far as, for example, through the bilateral consultation mechanisms, which we had recently last January, and the foreign ministry consultations. So these are diplomatic efforts that implement or are in line with the President's directive on the primacy of dialogue and consultation to manage their disputes in the South China Sea. And thirdly, of course, our leveraging of our partnerships and alliances with like-minded countries through multilateral maritime cooperatives, activities, or defense agreements, defense cooperation agreements. This is to share our vision of responsibility of promoting peace and stability with like-minded countries. And finally, of course, our commitment to enhance our domestic capabilities. So these are the 4 issues, the 4 core dynamics of maritime statecraft in as far as the South China Sea is concerned. I forgot to the second question of the Chinese participant. Oh, I remember what other practical measures that the Philippines. So I'm not talking simply about the Philippines per se, but as you mentioned, Irene, in the context of the wider region, ASEAN. Just to mention in my statement a while ago, we had the ASEAN Declaration on Maritime Cooperation. And the 2 concrete proposals is the establishment of the ASEAN Coast Guard Forum as a sectoral body within ASEAN, and the establishment of the ASEAN Maritime Center. Now, with respect to China, we have on board, currently on process, is the draft memorandum of understanding between our cooperation between the 2 Coast Guards. So these are some of the evidences that dialogue and consultation, not only in the Philippines, but within ASEAN, is continuing. Thank you.
With regards to the first question, I would like to respond in a way that I think that is more on government officials, but I myself am an academic. So what I see, how to make sure that you get things done, particularly because you did mention about how to improve something like that, right? That was the question with regards to the approach. That's the reason why we have to have more dialogues. But just look at it this way. Indonesia has resolved its maritime boundary disputes with Australia. I think almost all has been resolved. But with Malaysia, we have a number of maritime disputes that we have yet to overlapping maritime disputes, maritime boundaries. I would like to refer to, particularly in the celibacy. In the celibacy, I think we have resolved the dispute back in 2023. But with regards to Ambalat, with regards to the Straits of Malacca, and also with the maritime delimitation in Pedra Branca area, because in that part we still have overlapping maritime. We have not drawn our maritime lines there, maritime boundaries there. So why is it with other countries outside ASEAN, particularly this is based on my observation, Indonesia managed to resolve its maritime disputes quite quickly, not really quickly, but it get finalized. But with Malaysia, sometimes it got a little bit tricky by the way, but in a way that we tend to postpone and until there is an episode where we keep accusing each other of stealing fish. So I believe that we should learn from how you do it with Australia we managed to put a final say on it. And only then we can, maybe because Australia is not your immediate neighbor. You know, sometimes when we are talking to our immediate neighbor, the dynamics are different. So maybe we should, in order to resolve disputes, not only with Malaysia, with other countries within ASEAN as well, we should put that closeness aside first in order to put an end to maritime disputes that we are trying to resolve. That is how I look at it as an academic. Because I had this discussion with my friends, also academics from Indonesia. They say that more often than not, we sometimes postpone our discussion because, okay, let's have teh tarik first. And then we forgot to deal with the issue at hand. So basically, maybe we could look beyond ASEAN on how we resolve disputes with other countries beyond ASEAN, and we can bring it back so that we can bring it back and apply it here, so that we would resolve our disputes as soon as possible, so that it will not be taken to the next 2 or 3 generations. That's how I look at it, sir. I hope I answered your question. Thank you.
Okay, thank you very much. As much as I would love to, keep the discussion going on, I would like to close this session. Thank you very much to my 2 panelists and to Prof. Zheng, who was unable to come, for the very rich and very interesting discussion. And as we all noted, we want peace in this region, and definitely the award 10 years on, another 10 more years to come. We are definitely going to be discussing still the same issues. So let's agree to disagree, and in peaceful manners, right? So with that, allow me to thank everybody for this panel. Thank you.